In view of all the discussions, it has to be held that the claim of the writ petitioners must be allowed. Benefits claimed under 6.2 must be given its full effect. In respect of the transactions undertaken by the petitioner, the findings of the assessing officer in WPT so-and-so treating such and such amount to be sales to others in the absence of valid C forms are interfered with and set aside. Similar findings of the assessing officer in WPT so-and-so are also interfered with, set aside. The sales made by the petitioner to that extent shall be treated to be subsequent sales in the course of interstate trade and commerce, and full benefit thereon shall be granted to the petitioner as is available to the petitioner under Section 6.2 of the Act of 1956. Impugned orders are therefore interfered with, set aside to that extent that the benefit in respect of sales made to so-and-so was denied. Impugned demands are also therefore set aside and quashed. Petitioners are entitled to be granted full benefit available under 6.2 of the Act. For the sales made to respondent number 4, written petitions are therefore allowed and disposed of. Except orders, if any, stands merged. Pending IAs are also disposed.
Public.
Yes.
Lordship, one petition is there 5328/2021. In this matter, hearing has already been, it's over, Lordship. So I'm trying to place some more judgments, Lordship, 2-3 more judgments.
That regularize it.
Yes,
Pension.
yes, Lord. Next week, Lord. Tuesday.
No, next week. So
It will be only for 15-20 minutes.
we'll have it on 19th. So, sorry, not 19th.
Pushpa will not be available on 19th. Lord.
BF 19.
We are
17th?
he has a personal difficulty on the week. I think 16th. Lord.
On 10th, then, Lordship. It will not take much time. I will only place the judgment.
That is it.
You need to correct.
So see, you may place a judgment.
Yes.
But if you want to rely on, then it amounts to rehearing to that extent. So we'll need to revert back to whatever was there and how these judgments are relevant, what is the
Lordship.
proposition you are proposing to rely on,
Lordship.
and similar counter arguments may come from the other side.
Yes, Lord.
Lordship will take
So far as
15
dates are concerned, I have no issue, Lord. Then Lordship may take up this matter after 19th.
24th or something, is it available?
must be Lord. I will inform the court master. Lord.
Yes. 24th.
24th.
I have no issues. You can take it any day.
I will inform the Lord. Court master.
Obliged,
Lord.
Or we can have it in July, immediately after reopening.
problem.
Let me inform him. If it is from 24th, I will inform the court master.
Let it be in July. 24th is the
Motion week.
last.
Motion week. Lord.
So it's the last day.
Last week.
Not possible. We can have it immediately on 15th or 17th or whatever in July.
I'll inform the court
You
master.
inform
If Lordship allows me.
Yeah.
Much obliged. Lord.
Obliged. Lordship, we consider our side, Lordship. I guess to mention at least 15, Lordship. Lordship, I kindly think to make after 3 weeks, Lordship. I have to file my equity in this case, Lordship.
16.
16, Lordship.
1/6
One.
paper to be listed after 4 weeks, enabling the respondents to file their affidavit.
Obliged.
Council. Yes. Yes, council for the petitioner is also present.
Obliged.
May please, your Lordship. Lordship, with regard to item number 19, your Lordship, the respondent has filed an affidavit today, which was received by us yesterday, Lordship. That may be called for, Lordship. Otherwise, Lordship, very small issue is involved here in
Yes, Lordship, I am also, this may be called, Lord. Item 19.
Let us have it on Monday or Tuesday.
Yes, dear Lordship.
Let it be in the, let it call your Lordship. Let us see, Lordship, because
What is the point in calling it? We have to go
that-
through it.
because that additional affidavit only pertains to the petition. Yes, Lordship. On Tuesday,
Let
your
it be
Lordship.
on
then.
Monday or Tuesday. What?
On
Lordship.
Tuesday, your Lordship. Then on 10th, your Lordship.
11.
That will be a
Will it
miscellaneous
say
day,
11?
Lordship. Otherwise, it is like it is
11.
for disposal.
It's for 11.
May I please, Your Lordship? Lordship.
The affidavit stated to have been filed by the respondent.
Additional affidavit on behalf of
Additional
respondent number
affidavit
3,
shall
Lord.
be connected to the case record by the next week, by the next day.
On 11th.
Yes, dear.
Much obliged.
May I please, Your Lordship? With due consent from the other side, Lordship, I beg to mention item number 14. It's a part-hard matter, Lordship, but the conducting counsel, Sri S.K. Chakraborty's younger brother, expired day before yesterday. So we seek for a 10 days accommodation, Lordship. May I pray this matter may be fixed
It
up on
is
16th?
Submitted that the conducting council, the SK Chakraborty brother expired, is in bereavement. Therefore, adjournment is sought for.
16th or
It's
17th?
the matter after 10 days.
16th, 17th, any day, Lordship.
Let's begin on 18th.
18th, Lordship, the Shraddha ceremonies, Bhoj will be on 18th.
Then
So
they
16th, 17th, any day.
let
16th,
it be on 20.
20, Lordship.
It's on 20.
Most obliged.
May I please, your Lordship, beg to mention item number 7 and 8. Kindly pass over for the day, Lordship.
7 and 8
Yes, Lord.
items then passed over for the day. We listed after a week. The request made by the council for the
Right.
Let please, your Lordship. May I pray for listing of a transfer matter on Monday.
listing. Listing will be before the other bench. Court number 5.
Lovely. May I please, Lordship, for listing of a hearing, Lordship.
Court number 5.
May it please, your Lordship, I beg to mention item number supplementary 20, Lordship, with the due consent of the other side. My Lord, in this matter, we are supposed to file our affidavit, my Lord. We need some more time, my Lord, to file our affidavit. Kindly, my Lord, grant us 2 weeks.
20 in the request made
Supplementary 20.
by the standing council for the EAD. Then referred to be listed after 2 weeks. Submitted that the consent of the council for the
And
petition.
for interim order is there, my lord.
Interim order is any, will continue. It's after,
Interim order may be continued.
yes.
Obliged.
continue.
Obliged.
Lordship, in regards to item 13, with consent from the other side and praying for 2 weeks adjournment.
Item
13,
Lordship, they have previously also strict time, Lordship. 1 week may be given. Next week.
Lordship, we have oral instructions that the inquiry, disciplinary inquiry is in the concluding stage. So they have sought for 2 weeks time.
Then also a date will be fixed.
Item 30, the request made on behalf of the council of the respondent department, DNR. Understand, but it's the after 2 weeks. Mr.
Amen, Lordship.
David appeared for the 20. Third.
Obliged, Lordship.
Matter regarding compensation appointment, Lord. And petitioner is already selected in DLC, Lord. Now his petition is pending in SLC. We can prepare for,
But in view of the notification, have you challenged the notification?
Lordship, I am telling.
You challenged it,
Lordship. Already our high court.
covered,
Yes.
covered.
Day before yesterday, your Lordship, similar matter was disposed of by your Lordship.
Do you have that order number of the case?
I'll just give. you, Lordship. I'll just give.
The council to be filed. Committed and signed, ready. Similar it can be to be disposed of by the court. I order dated and to pass the reporting. Passing directly. that- Right. Yes. This
went to a disciplinary proceeding, my lord. It was dismissed from service, my lord.
Yeah.
Now, my lord, we have prepared an appeal, my lord. Now, my lord, he is retiring in the month of September, my lord. So, my lord, since the appeal has been filed, my lord, my prayer will be
Yeah.
limited.
It will not dispose of.
Not disposed, they will keep it pending, my lord. So, my lord, that will be disposed in particular time frame, my lord. That is my lord, simple prayer, my lord.
Let them get the instructions at least. What is the stage of the
My lord, my lord, my lord.
Lordship, revenue, they will,
call for the revenue or you convey the order?
I will convey Lordship.
Heard?
Mr. Hendick, he was here only.
this writ petition filed with the prayer. Petitioner was dismissed.
Yes, ma'am.
Dismissed
Dismissed.
from service pursuant to disciplinary initiative. And again, he agreed he had preferred an appeal before the statutory appellate authority. So the appeal was filed when?
So the appeal was filed, my lord, page 64, my lord, was filed 5/4/2025, my lord.
5/4/2025.
2025. Initially, it was filed earlier, 31/1, my lord. Then, my lord, it was before the revenue department. Then they said, it has to be before the general administration department. So it was refiled on, my lord, 5/4/2025.
Any number?
Was
Number.
filed on 5/4.
2025.
5.
Same or
Submitted that the petitioner would have superannuated
Yeah.
the month of
Yeah.
September 2025. And
Bill
therefore,
pending.
council would,
Oh,
for a direction to the
no, I
appellate
have
authority
no.
dispose of him in a fixed time
You do what?
as expeditiously as possible. Mr. J. Hennick, representing the revenue department. will
I'm
take
appearing for 3 and 4 lot. 1, 2, or no?
J.
Or no, or no.
J. Hennick for 1 and
1 and 2.
although notices the
Yeah.
petition
Oh, no.
has not date. Extra copies of the written shall be furnished to any appropriate requirement.
Actually, department.
When can you get?
This is he is serving as a Jari Karam. Deputy Commissioner is
Lordship.
taken up.
Both
Lordship.
The deputy commissioner is the authority who's passed the impugn order, my lord. The appeal is before the commissioner, my lord.
we'll have it on 18.
Okay.
18.
18.
Oh, yes, Lordship.
Obliged.
Deeply obliged.
If matters come up for orders.
Hmm?
If matters come up for orders, then the matter has been heard by your lordship before. Can it be fixed on 24th for admission hearing law? Reading session
24
complete.
will come in. Like, what is the issue here? For appointment of arbitrator?
Appointment of arbitrator.
What is your objection?
Lordship, there is a clause for DRC, lordship.
Hmm?
In this, we have filed our application opposition to lordship. Lordship, can you page your lordship? Page 55, your lordship. Repetition, your lordship, 55. Okay. There is a clause 25, your lordship.
There is a
Clause 25, your lordship.
clause
This is
25.
the part of the contract, your lordship. And lordship, here it is a clearly stated that if any dispute arises between the parties, your lordship, he has to first approach the DRC, your lordship. But without the lordship exhaust the procedure, your lordship, they immediately come to your lordship. Now we dispose the lordship.
You have no report.
We have approached lordship, but they have to constitute the DRC within 15 days. So as per agreement, they did not. That's why we have approached this honorable. Lordship may have a look at page.
Have it on.
Page 17, not
24 or 27.
24 is the last day. That we told.
Immediately after vacation, lordship.
Matter be listed immediately after vacation and trade has jointly trade by some. Immediately after vacation or again.
deeply obliged.
That is a lot. Okay, there is a office notice reflects in the code, but I'm sorry, I couldn't verify the office notice. And actually what happened, there is a detailed order passed by the honorable court, maybe 2 days back. But on last occasion, the council representing the department paid for
adjournment for filing affidavit, but till date they have not filed any affidavit.
Respondent five is refused.
That is, my lord, already deemed to be served as per Lozima order. Service of notice is complete in respect to action number 5. There is an order passed by your lordship. Lordship may kindly peruse that order.
Now, no, why is it listed today?
Maybe for
Notice
the
notice there.
report, maybe that's why this paper is listed, but there is an order from the Lozima. The service is already
Who's
complete.
for the respondent here? This is which department?
Lordship excise.
Excise department.
Lordship. The father of the petitioner is working as a constable. He expired in the year 2021. Thereafter, we are not receiving the family pension and other benefits. And there is no dispute between the private respondent also because
Yes, the government advocate, please inform the excise department what instructions. They have not come, they are not here. Heard Mr. Botaku and also Mr. D. Bora. Government advocate. As per the last order, the standing council excise department was required to
May I please, your lordship? Lordship, the affidavit has been sent for vetting. That may be granted, lordship.
required to file an affidavit for instruction. The basis of instruction. Still appearing for the excise department. Say your name.
I'll go.
That the affidavit is under preparation. They require much time,
2 weeks time. lordship.
2 weeks time. File the affidavit. Considering the parent name, that paper will be still after.
date may be fixed. Before vacation, any date.
Before vacation is difficult. 20 or 23. Today is 6. Today is 6. 23.
So let's.
It's on 20.
Lordship, on last occasion, there is a specific query by the Honorable Court Lordship regarding the date of submission and receipt of the representation. So we have got it. It was on 8/9/2022, Lordship.
Now, what is the status? Is it disposed of or representation
Uh,
or what orders were passed?
Lordship. Since the petition name has not been
We permitted you to obtain instructions with regard to the status of the
Lordship.
This is that home guard,
Yes,
not
Lordship.
call for duty.
Yes, no. Only 15 days, my lord, during that period. Election.
Then let them consider the representation.
Yes, no.
Where is your representation?
That is at page lordship 12.
Red Bird, and it up. Right.
Lordship, there is a criminal case registered by
But it-
Tezpur PS case number 1219/2011, Lordship.
Whatever it is.
And
to
this is
dispose of-
pending, Lord.
to dispose of the representation.
Lordship.
Pass an order
Lordship, Lordship,
and serve him a copy.
Lordship.
The petitioner, in the petitioner's case that he was selected in the recruitment process for being enlisted as a home guard and was sent for rural basic home guard volunteer training course at the first Assam Industrial Security Force Battalion. So he completed the training and thereafter he was appointed as member of the home guard under section 6 within bracket 3 bracket close bracket small a bracket close of the Assam Home Guards Act 1997. Except for a brief period of 15 days during the election day, during the election in the state held in the year 2019, the petitioner has not been called for duty as a member of the Home Guard. He had repeatedly approached the respondent authorities requesting him for deployment as he is a trained Home Guard. However, his pleas, his prayers have not been granted. So he filed the representation dated 8/9/2020, but that representation also was not disposed of, and no information is forthcoming from the respondent authority compelling the petitioner to approach this court by filing present petition. On the last occasion, on the last date, April 23/5/2025, the respondents were permitted to obtain instructions as the status of the representation filed by the petitioner on 8/9/2020. There are today when the matter is called up, there are come to the respondent updates or instructions that the representation has been received, but she has no instructions as to what orders have been passed from the state representative. On such instructions being placed before the court, it is evident that the authorities did not proceed to pass any orders of the representative. Considering the prayers made, limited prayers made in the petition that petitioner being a trained Home Guard, his only prayer is to be called or deployed for duty like other trained Home Guard. This court, whether it is appropriate to close the petition at the state and directing the respondent number 5, namely the commandant of Home Guards, to look into the grievances of the petitioner as
Dispose of
ventilated by the representation dated 8/9/2020, and upon hearing the petitioner's part and orders thereon, the respondent I will dispose of the representation by filing its standing order, and a copy thereof is served with the above information that to dispose of. The direction shall be carried out within a period of 30 days from the date of
30 days, Lordship. Kindly make it 2 months, Lord.
60 days from the
Lordship.
receipt of a certified copy.
Deeply obliged, Lord.
My lord, at page 58, my lord, there has been already a previous read. And on 59, there was an order, my lord, that after under such circumstances, the court is of the considered view that since the department proceedings have already been initiated, isn't it, my lord? And while passing such necessary orders, the department authority will also decide in the question of the writ petitioner. The entire exercise will be completed within a period of 2 weeks from the date of receipt of the certified copy of the order. This was passed on, my lord, 22/4/2024. Thereafter, my lord, this order was not complied with, my lord. So we had no other option but to again come before this honorable court. And the present writ petition, my lord, on 7/1, my lord, 7/1/2025, there was a speaking order by this honorable court, my lord, and thereafter such strict orders were again passed. But till date, my lord, no decision has been taken on the, my lord, inquiry report. And my lord, the petitioner is suspended on 6/3/2023. Now 27 months in suspension, my lord.
Yes,
Lordship, at the last occasion also it was stated by the department that the matter is sent before the APSC for taking your views, Lordship.
for what? The departmental proceedings are complete.
Yes, Lordship. But it is sent for penalty, Lordship, for on imposition of penalty in respect of the official. So that's why.
Are you challenging the departmental proceeding?
My lord, I have been served with a copy of the inquiry report, but no final order has been passed.
Actually, they're waiting for the views of the APSC.
My lord, but my lord will see on last many occasions, my lord.
Have you received your subsistence allowance?
I am receiving that, my lord.
So when were you suspended?
My lord, I am suspended on 6/3/2023 with effect from
Where is that order?
4/3. Suspension order is, my lord, at page 30. Presentation.
This is
24,
the-
24, my lord.
This is the disciplinary.
My lord, 24. Lord, therefore, request can you
You're under team suspension.
placed under suspension with effect from the date of arrest, that is 4/3/2023.
Then
Then thereafter, my lord, I petitioner approached before this honorable court, my lord. That point of time, learned counsel for the respondent, my lord, submitted that the departmental proceeding is over, a decision is to be taken. So my lord directed that exercise may be done within 2 weeks. That is in the month of April 2024, but no decision has been taken.
see, after you were suspended,
Yes,
within 3 months, the show cause notice was issued.
but my lord,
Within 90 days.
at that part, my lord, I have subsequently, this honorable court has taken the stand, my lord. It should be from the date of suspension. So from the date of
Date of suspension means
Yes.
the effective date of this is order of date of suspension. Order of suspension will have to be read on 6th of May with effect from the day you are arrested.
But that was the earlier view, my lord, but the coordinate bench have some, my lord, other judgment also. I have that judgment, my lord. Later on, my lord, it was decided that it will be from the date of suspension, that will be 6/3. So, my lord, my 90 days expired on 3/6/2023, but till then, my lord, no statement of allegation was served to me, my lord. Neither it was reviewed.
So the rules are not on that. What does the rule say?
Rules say, my lord, from the date of suspension.
What does the rule say? 6/3?
Yes, ma'am. I have stated in my paragraph, my lord.
Six two.
My lord,
the rules are very clear. It says until further orders. 6/2, it was suspended.
Yes.
Until further.
6/3, my lord.
6/2.
My date of suspension?
No, the rule 6/2. Do you have a copy of the rules?
No,
Yes, we are giving you. Have a look. Yes.
Six two of the Assam Discipline and Ethical Rules until further. My lord, 2.1.8 of the said this manual, my lord.
Look into 6.2.
Yes, 6.2 I have seen, my lord.
The rules are that until further orders.
Yes, but my lord, it has to be read with my humble submission, my lord. It says the following principle and procedures will with regard to suspension and strict compliance.
That is the guideline. The rule governs the guidelines. The rule says until further order. We can accept that you are placed under suspension without any proceeding. Here the proceeding has been issued if we take it 6-3, 6-5. Because you were arrested from 4-3, the department, when was the department intimated that you were arrested?
My lord, I with most humble submission, my lord. That was the trend in my lord during 2000, first part of 2024.
Show us the judgment.
Yeah, yes. No. My lord. Ajay Kumar Chaudhary was from the Honorable Supreme Court, my lord. Yes. Thereafter, my lord.
We don't use the courtroom for your preparation. You prepare and come back next week.
My lord.
The rules are clear until further orders.
My lord, second half, my lord.
Not why second half?
I have enough, madam, enough judgments are
You
there.
have judgment when you are unable to find out.
Vinod Kumar Payang is there, my lord. All right, my lord.
Vinod Kumar Payang, there was no disciplinary proceeding. He was kept under suspension. Therefore, Ajay Chaudhary. Here is a case within 3 months, Tokos was issued and has gone on. You may still have a case to argue, but that information I cannot share. It is for you to find out. But 3 months, Ajay Chaudhary is not applicable to you.
Now, my lord, my last humble submission before lordship. There has been continuous orders of this honorable court. There is a time limit always fixed. My lord, that has been dragged from 1771 till now, my lord, no decision has been taken.
That is not, you are not challenging that. You are challenging your suspension.
Yes,
with
but
effect from not completed, not reviewed within 3 months in view of Ajay Chaudhary. Therefore, it should be
my lord,
interfered with.
their submission were always, my lord, within some time, their final judgment will be passed. Final, that was not passed.
Don't mix up everything. You have different compartments. One is suspension, no review, no DP beyond 3 months is one category. Your case does not fall into that category. We'll take it up next week if you are ready.
My lord, yes.
13. List of 13. We request it to the company.
That is a lot. My lord, in this matter, almost trading is done. My lord, matter is ready. Final disposal will make. Trading is already completed. Matter is ready for disposal, my lord. And here, my lord, the issue petitioner, my lord. If you lordship take my affidavit reply, the chronological list of dates I have for your lordship convenience.
What is your grievance?
My lord, can you have a look at the page, my reply first, my lord? My
First
reply, my
tell us
lord.
what is your grievance?
My grievance is that, my lord, in the I retired from service in the 2007, 31st March 2017. Prior to that, my lord, and as per the financial 2016 and 17, I have been revised by pay scale from 11,850, my lord. Then, my lord, very next month, my lord, they again deducted the same amount that my as my original amount, basic pay fixed, that is 11,430. Therefore, subsequently, I have made different of representation before them to rectify my fixation of salary, but they have not considered and rejected. And moreover, another two priorities here, my lord.
Where is the rejection order?
Yes, my lord. Page 1640.
Before publishing my friend lordship. So there is a court's order of 1 of 1st of the October 2024, the matter is supposed to go back to CAT lodge. This is their jurisdiction. 1/10/2024.
This is a matter of 2019, my lord. And this intimation made.
Otherwise,
in
pleadings are completed, lord.
2025, my lord.
Where is the notification? Some notification is referred.
Lord.
You are an employee of Brahmaputra Port.
Yes, my lord.
Where is the notification, please
Lord.
point out?
My lord, my humble sum in this matter, my lord. I
No,
did.
if the jurisdiction is not there, why are you submitting? You
But
first
the-
satisfy on the jurisdiction part.
Since, my lord,
You show us the notification by which the.
my learned friend is raising this issue, my lord. Let him place in the notification.
Is it
Lord, I will submit on lord. 1 week's time we granted. We'll
1 week? Right, please again on 13,
Lord.
enabling the learned CGC.
SS.
You are appearing for
SS Roy.
SS Roy, CGC to place before the court the notification by which the court had earlier recorded in its order dated 1/10/2024 that the matter, the appropriate forum for a decision in the matter is the Central Administrative Tribunal, Guwahati. From let this notification be positively placed before the date 13.
Outline, Lord.
Please, my lord. Petitioners, my lords. That he was challenging the non-finalization of a departmental proceeding which was initiated in 2001. And also, and he was thereafter, my lord, allowed to retire. Thereafter, my lord, his pensionary benefits and all retirement benefits haven't been computed till date, my lord.
Departmental proceedings over.
A penalty order was issued in the year 2012, served upon the petitioner in 2013, my lord. His comments were sought for, my lords. He offered his comments immediately thereafter on 2 occasions, my lord. No response forthcoming, my lord. Thereafter, he retired in the year 2019. His pension has not been released. His salaries has not been refixed, my lord, since the year 2006.
Yes. Why?
No, my lord, here is a case, my lord, where no final order has been passed.
In
No final order has been passed, and that, my lord,
final order as regard.
as regards, my lord, penalty arising out of the inquiry report.
Right.
That means, yes, in other words, my lord, the DP has not yet been concluded. Now the difficulty is here, my lord. If lordship may be pleased to come to, my lord, page 39 of the writ petition, that is the inquiry report. That is the inquiry report. And there are 3 definite charges. Charge number 1, lordship will find at, my lord, page number 40. Page number 40, that is charge number 1. The petitioner was caught red-handed while he was accepting a bribe of rupees 1,000. Of course, that is the charge. Then, my lord,
No. Why are you taking us to the charge? Disciplinary proceedings, inquiry has been completed.
yes, now the difficulty
Report is
has
submitted.
no, my lord, after this inquiry report was submitted by the inquiry officer, he was asked to furnish his, my lord, response against the inquiry report. That we have to do it as an employer. He was not doing that. And in fact, he became untraceable. So therefore, under that circumstances, the department had to go for even paper publication, newspaper publication. Then finally he came and he submitted, my lord, the response against the inquiry report. That lordship will find at page 66.
page 65 is the paper publication, newspaper publication. It is something very, my lord, strikingly.
All right, he submitted finally.
He submitted. Now, thereafter, this writ petition came to be filed, my lord, and this honorable court was placed in the interim, my lord, to not to thereby restraining the authorities not to proceed with the departmental proceedings. Now, I have definite instructions from the department. They are waiting, my lord, to complete it. But because of the interim order, my lord, they are unable to complete it.
Interim order.
Yes,
There is a status quo order.
status quo order.
Then why are you saying that it was
My
not
lord,
proceeded with?
Yes, my lord.
Now,
What
if,
I'm-
otherwise, my lord, writ petition in a sense has become infructuous. If this writ petition is disposed of, my lord, directing the respondent authorities to complete the departmental proceeding and to, my lord, pass a final order.
That, my lord, respectfully, my lord, cannot be the position, my lord. Petitioner having retired in 2019, my lord, a DP initiated in 2001 cannot be continued without referring to section rule 21 of the pension manual, my lord. If anything has to be done, has to be only interference they can cause is with the pensionary benefits. And the condition precedent for that exercise is a pecuniary loss that the government has to ascertain. So the allegation here is the petitioner was
You are challenging the inquiry.
Inquiry?
Yes, my lord.
He is challenging the inquiry.
Challenging the inquiry report.
Yes.
Yes, my lord. Because now
Then
the
we'll have to hear it.
Yes, well, the only difficulty I'm facing, my lord, the issue is simple.
Facing a difficulty which is self-inflicted.
My lord,
You have come to the court challenging the inquiry. Inquiry was completed. You got an interim order on a status quo. So therefore, the proceedings have
my lord,
not gone
the
ahead.
inquiry report, my lord, was furnished to the petitioner in the year 2013. Now, we categorically stated in our petition that the response as sought for were furnished by the petitioner in 2013 and 16 thereafter. In response to that, they have not replied to that contention of the
How
petition.
can they, when there is an interim order?
No, my lord, this is with regard to the petition.
Whatever it may be, but as on date, you are enjoying an interim order status quo.
My lord,
For that reason, my lord, time and again, my lord, that departmental authorities are
You can
ready.
vacate the status quo and let
Lord,
the
to conclude.
respondents decide on this issue.
my lord, the decision, my lord, respectfully, that decision cannot happen because the petitioner has now retired, my lord. He has superannuated, and my lords will kindly take Rule 21 of the pension matter. My lords are aware, my lord.
21 is on a different plea.
Yes, my lord, because
the case where you have invited an interim order, stop the disciplinary proceedings, and you have retired. Now this Rule 21, that 4-year period will have to be calculated.
No, not for the purpose of calculating the 4-year period, my lords. The Rule 21 only limited to the condition precedent that the exercise under Rule 21 can be carried out at the behest of the Honorable Governor, only where there is a pecuniary loss suffered by the government. Here, the allegations against the petitioner was that he had received illegal gratification. He was eventually honorably acquitted by the Honorable Court.
The problem is that you have a status quo order. The inquiry, whether it is in your favor or against you, is before the authority. Inquiry on its own does not give you any punishment or absolve you of the allegation. It has to be taken up by the disciplinary authority. They can't do it because of the interim order, which you have prayed for. Now, in the event of that, your pension, assuming they want to even refer it under 21, they can't do it because there is no conclusion. How will they?
Then acting on an inquiry reports subsequent to my superannuation, my lord.
You are challenging the inquiry, will hear it.
Well, the only issue that is the petitioner is facing, my lord. His wife is terminally ill, my lord.
We are at the cost of repetition, we are saying that these difficulties are being self-inflicted. You have invited an interim order staying the petition. Until and unless the disciplinary authority comes to a finding, let us say it imposes penalty. There's no question of putting a challenge to that. You are questioning the proceedings itself.
Now, on the account of the protracted delay as well. Rule 21 is one of the limbs of my argument, my lord.
Rule 21, you have not even reached the borders of Rule 20.
Now, because
of the interim order.
My lord, respectfully, my lord, subject to my lord's satisfaction, my lord. Rule 21 will perhaps come in moment I superannuate in the year 2019. My lord. For them to even at least contemplate proceeding against the petitioner, they will have to take recourse to Rule
You
21.
cannot proceed because of the interim order.
No, my lords, the inquiry report came in 2012.
Inquiry
I
report-
superannuated in
inquiry
2019.
report was initiated before you retired.
Yes,
Therefore, no Rule 21.
no Rule 21.
After you retired,
And I
there
had,
is an interim order.
after
suspending
I
the
retired, my lords, after I retired, they sat back without doing anything for 4 years, my lord. 2023, they suddenly wake up, issue a paper publication. I respond to it, my lord. Now, if they are to act on the
Once
inquiry
you have
report,
retired, once
Yes.
you have superannuated, and if there is nothing done with your pension, you had your remedies open for you. You had your remedies in law. You're not remedy-less. You chose not to come. That's all right. Now, you have retired. There is an interim order saying that don't proceed.
on the, my lord,
Then how is Rule 21 applicable?
because, my lord, now the petitioner, my lord, subject to lordship's finding merit in my argument, my lord. The petitioner having retired, my lord, the inquiry report is of 2012, furnished to the petitioner in 2013.
Rule 20.
My lord, I have a judgment of this honorable
No,
court.
no, we'll go to all
Yes,
your judgments.
yes, yes,
And more.
Yes.
But satisfy us that
Yes,
the
ma'am.
rules are applicable.
yes, ma'am.
Yes.
Yes, madam. The governor of Assam reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering the recovery from a pension of the whole or part of any pecuniary loss caused to the government if in a departmental or judicial proceeding the pensioner is found guilty of grave misconduct or negligence during the period of his service, including service rendered upon so informed. Now, on this very issue, my lord, the honorable division bench of our honorable court, my lord, had dealt with this issue, my lord, and I just placed this judgment, my lord.
First, tell us what you want to submit.
Yes, my lord, the issue is for exercise of Rule 21, moment a employee superannuates, the employer-employee relationship ceases to exist, all ties are snapped. The only recourse available to the government then for a DP initiated during the service of the petitioner or the employee is to take recourse to 21. And 21 has to be only on the condition precedent that a pecuniary loss is suffered by the government. Here, my lord, the allegation against the petitioner is receiving
You read Rule 21 again.
the judgment perhaps clarifies
No,
the issue.
you read Rule 21 again.
Yes, yes. The governor of Assam reserves to
Yes, yes. Carry on.
the governor of Assam reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering the recovery from a pension of the whole or part of any pecuniary loss caused to the government, if in a departmental or judicial
Now, here
proceeding.
you pause.
Yes,
Pause
ma'am.
to the government.
Yes.
If in a departmental or judicial proceeding,
Yes.
pensioner is found guilty,
Yes.
you are not allowed the process to continue.
So the penalty, the inquiry report, there is a charge which is
There
proved
is a
against.
charge, but
Yes.
the charge is proved, not
Yes.
proved. Disciplinary authority accept, does not accept, issues a disagreement note. How many options are there?
So
But
the
there
only,
is no finding.
yes,
The
the,
inquiry officer is not your disciplinary
But-
authority.
that issue will also have to be decided with the delay that the inordinate delay that they
Why
caused.
did
my
you
lord.
allow the authorities to proceed?
My
There was
lords,
a delay. There was a delay.
2013,
You have
my-
caused a further delay by inviting an interim authority.
2013, my lord will appreciate inquiry report
When
of
did you file the
2012.
writ petition? 23?
23. No,
When did
immediately
you-
after
when
they
did you
issued me the
superannuate? When did you superannuate?
2009,
2009.
19.
And you come before the court in 23.
Yes. Only upon receipt of the paper publication, my lord. And I had furnished, and there are representations before that as well, man. My pension may be computed, my lord, and
We
be
are,
released,
we are absolutely sympathetic
my lord.
to you.
Yes.
But you tell us whether you want the interim order to be continued or vacant.
That issue perhaps, my lord, will be.
Third plenary council.
May I, my lord?
The proceedings in this matter are complete. To be listed for hearing in the month of August. First
Sir.
week.
July, my lord. There is only
July, 2 weeks are on holiday. Enjoy your
financial
holiday.
difficulty, my lord. The petitioner's wife is terminally ill. She's suffering from cancer.
We are again at the cost of repetition.
Very good.
You are not, you are inviting this at the cost of the interim order. Not only an interim order, status quo. And the respondents are gleefully not filing a vacating petition. What else can we do?
May I prefer a fixed date, man?
Of course, can give you a fixed date on 5th of August. Right? This will be Mr. Porpujari, Ms. Sharma, Mr. Mehdi, is for the respondent.
And so, like,
Your Honor, I am praying for further time to find my affidavit. I'm appearing for all but respond number 5.
Date took time twice in fact. So.
Affidavit has been sent for waiting, my lord, it has not come.
Now you know how it feels to be on this side.
And that's why I'm not.
When the government prays for time,
That's why.
time after time. Here. Mr. Elmar Adhikari, and then the CGC
Yes, ma'am.
prays for better time. Completely posted.
Right, respondent.
OT appeals. OT appeals to respond. This after 4 weeks.
Obliged.
Yes.
On the last occasion, my lord,
we had suggested our arbitrator's name, the last occasion.
just the name of Honorable Mr. Justice J.R. Midha of Delhi High Court. No problem. There is one small development which I thought I must inform your lordships. I had a word with Mr. Manojit Bhuyan, judge. This letter for arbitration that was requested for an appointment was sent in 2014, but it seems like he is slightly tied up and says that he may not be in a position to finish this arbitration in terms of rules 16, as you understand. So he said that I would like to recuse myself because it will be difficult for me to, because I have other assignments. In that case, I spoke to my clients and they have agreed for the name of consent has been taken of Justice, retired Justice K.M. Murari. So if the lordship's wish, I think that name can be.
For you to suggest.
I am suggesting the name of retired Justice K.M. Murari.
Then I will have to now seek instructions from my client as to whether there is any conflict.
You will have to agree that
I have.
there is no question of.
He suggested this name, which I am not objecting. So I don't think there is any reason for him to object.
You have no role in
yes,
this.
I mean, I'm sure he.
I understand, but when this name was presented by us on the last occasion,
you are given an opportunity to suggest your.
I have suggested, and it was. And they had taken the option to verify and then come before lordships to say that they have no objections to that. That opportunity should be also given to me because we knew.
Supreme Court, Honorable Court. Yes, K.M. Murari.
There may be some conflict of interest also from our side.
Presiding arbitrator will have to be appointed.
Yes, both of them will have to appoint the umpire.
So that process, unless you proceed with that, where is the occasion for the court to?
No, in fact, what happened, my lord, because we have already suggested the name of Mr. Bhuya, who is now.
Now he is recused.
Yes, and we have already spoken yesterday. The clients have given me a consent that Mr. Murari has agreed and his availability is also there. So therefore, I'm sure there's no conflict of interest and everything must have been spoken and then given. Therefore, I'm suggesting that Mr. K. Murari should be appointed. That's all.
We do that and we close it.
Yes, my lord. That's what I'm saying. I don't see any reason for him to go back and take an opinion because this is my nominee, my lord. That's all I'm saying.
Mr. R.B. Pupat, Mr. A. Sharma.
If we have any objections, if we have any conflict of interest.
You can't have an objection.
No, if Mr. Murari has been in the panel of All India Limited for some reason, for some advice or something, I do not know.
No.
In fact, that if there is some conflict of interest, I must be given an opportunity to inquire from my clients if there is some conflict of interest on that aspect.
He can raise it.
No, which they have done on the last occasion when my name was suggested.
The 12-1 declaration.
Yes, that's what I'm saying, my lord. In terms of that, they have spoken to him. Everything has been cleared. And then
both of you
declaration was not received by us.
Have punished the 12-1 declaration.
No. Then that's what I'm saying. So that opportunity has to be given to me. Let me
let
find
him
out.
also give it. I also give it, my lord.
We don't want to, because this is not our jurisdiction.
I absolutely agree. I absolutely agree.
Both of you to speak to the learned arbitrators and get their consent.
Yes.
And
I have got my consent, my lord.
consent along with the declaration. You
I'll
get
get
it and then
I'll get it, man.
we can close it
I'll get it. I'll get
on
it.
the next.
Therefore, I'm saying, Lordship, only one opportunity has been given to me.
Mr. Pukan, RB Pukan, Learned Counsel,
नाम तो वो
submits
KM
that
Vishnu.
Mr. Manojit Bhuyam,
वो वोटी का तो नहीं
former judge
है
of the Guwahati High Court,
Mr.
was earlier
Krishna
nominated
Supreme Court.
by the
कृष्ण मुरारी अच्छा
decide the disputes arising between the party
JM.
has subsequently recused because of personal reasons. Subsequently, the petitioners have approached
Honorable Mr.
Justice
Justice
Honorable
Krishna Murari. Supreme Court.
Mr. Justice K.M. Murari,
K. Murari. Krishna
Murari.
Murari. Retired.
former judge, Supreme Court of India, who has accordingly consented to be the arbitrator on behalf of the petitioner. So both the counsel, however, do not have instruction whether the declaration under 12 has been also received from the respective learned arbitrator. So, in view of the matter, parties are given 2 weeks, 3 weeks time, 2 weeks.
Also, we'll fix the date.
Any date, well, not Friday, otherwise it won't take too long. If it is next Friday, it should be. If it is not inconvenience, Your Lordship, I would like to.
All right. At
Sorry
the
for-
request of the party, the matter is listed again on 13th,
Yeah, I'm extremely grateful.
where surprise the court whether the declaration
Fine.
prescribed under section 12 was
Yes.
received by the party.
Great.
List again on 13th.
Extremely grateful.
Obliged, Your Lord.
My lord, on last occasion, your lordship directed me to produce the judgment of the Hindustan Petroleum. Hindustan Petroleum judgment, which has been referred in the judgment of this timing limited, my lord. And your lordship desired to have this judgment and according to Supreme Court, Hindustan Petroleum Corporation. In the para 15, that is para 15, my lord.
Yes.
This court in the case of such and such has held that the language of section 8 is preemptory in nature. Therefore, in cases where there is an arbitration clause in the agreement, it is obligatory for the court to refer the parties to arbitration in terms of their arbitration agreement, and nothing remains to be decided in the original action after such an application is made, except to refer the dispute to arbitrator.
So that is all right. This position is now ratified by the subsequent judgment.
Yes. So that being the position,
So
my lord.
we'll appoint Mr. Dhor.
Yes.
My lord, the only objection which I am on.
All you raise all objections before the arbitrator.
Yes. Under section
I mean,
16.
we'll make it clear that all objections as may be available will be raised before the arbitrator. You are alleging fraud.
My lord, just holding this fraud for a moment. The other objection which I have raised, that if the the partnership is dissolved by virtue of under section 43 of the Act of Partnership Act, the Gujarat High Court's judgments are there, which says that the parties cannot be forced to go for arbitration. I'm just placing.
Then there are subsequent judgments. that will
Yes.
affect
Even
that where it is necessary for a dispute to be resolved. You are amenable for it.
correct, my lord. And in fact, the judgment of IS Sami, and also reflects that if there is a serious allegation of fraud and involves some other parties also.
So will have to be prima facie, the court will have to be satisfied that your allegation of the face of it appeared correct. You are making an allegation. They are disputing it.
Well, they have made an allegation against
They
them.
have made a counter allegation of whether this court be completed. Wait these allegations to find out because these are matters by friends.
Correct, my lord. And
We
if,
can raise all the objections paper will learn it arbitrator, whether it has its jurisdiction to entertain.
but the judgment,
Then we'll hear the matter. You get a list of all the judgments that you want to refer to, rely on. We'll hear the matter.
there's a small thing.
What is it? We will hear the matter and pass an order whether this matter can, the facts, the allegations and counter allegations can, would it be feasible to refer it to arbitration?
My lord,
The only
these
thing is
matters
that-
can be raised before the arbitrator under section 16 of the act, my lord. Let
So
us,
you are right. We agree on that.
Yes.
But see, there is another question that if there is nothing to be decided by the arbitrator, what is the point in referring it? Hypothetically,
yeah,
if there is fraud and counter allegations, what will the
yeah,
arbitrator decide?
my lord, this position has already been decided by the Honorable Supreme Court, my lord. Your lordship will come to 2014 judgment, which I have given.
24.
No, 14. Two thousand fourteen 6 SCC. Case 6779. Please, my lord, first of all, I am taking to your lordship to para 18. Having found that the subject matter suit was within the jurisdiction of arbitration, it was held in such and such that the dispute cannot be referred to arbitration. This court approved the finding of the High Court, and since the case relates to allegations of fraud and serious malpractices on the part of the respondent, such a situation can only be settled in court through furtherance of detailed evidence by either party, and such a situation cannot be properly gone into by the arbitrator. This has been decided by the Honorable Supreme Court. Now, my lord, in my opinion, the aforesaid observations run counter to the ratio laid down by this Honorable Court Hindustan Petroleum Corporation. This judgment I have given. Now, my lord,
This again is a judgment by a single bench. This is a judgment by a single bench.
yes, but even though subsequently it was also,
This is a judgment by a single bench.
no, it
And
is
it has-
judgment
it
of the
has-
single,
It has over.
though
No,
it
that's the
has
law
not been
laid by the
overruled.
apex court also.
It has not been overruled. So far my knowledge goes, my lord, it is now, my lord, your lordship will come to para 24.
So we'll have to hear the matter. Hear it.
My lord, the matter unnecessarily be delayed, let it be.
What delay?
On Tuesday, my lord.
On
Or-
Tuesday, Thursday, whatever.
Or today, my lord, since the matter has been fixed for hearing, my lord, let
No,
it
it's
be.
not fixed for hearing in that sense. It was fixed for hearing to give them an opportunity to, if they agree that yes, it can be referred to arbitration, we'll pass an order.
there are some
But
subject,
they have raised an issue in a sense that when there are so many allegations and counter allegations, what will the arbitrator do?
Yes,
How will the arbitrator decide?
because so far the malpractice, misrepresentation, all these things are to be decided by the arbitrator.
but allegations against me as well as the other involving the other persons, third persons who are not in party to the arbitration agreement, whether the arbitrator can adjudicate that disputes
No.
also.
You
I cannot.
I'll
address the court on this.
my lord.
You address the court. We have accepted your argument for the time being that yes, everything needs to be decided by the arbitrator. Fraud, no fraud, whatever is
Yes.
there, taking the cue from the principle section 8 that if there is a arbitration clause, it must be referred.
Yes.
So, therefore, under these circumstances, why should the court, referral court, decide on this issue, which is fraud, which is not fraud? That is your argument. Continue with your reply on Tuesday.
Well.
Placed on Tuesday, Mr. Roki Bhatti, Mr. Ray Hall. He listed further hearing on Tuesday.
Can it be on 12th, my lord, because I have
12.
Arunachal.
12.
Obliged, my. Much.